Good evening, everybody. Thank you for joining us. My name is Lauren Bell. I sit on the board of the Learning Disability Association of Georgia, and we're super excited this evening to have Randee Waldman with us for our webinar. Randee is with the Juvenile Defender Clinic at Emory Law School. So she's going to be sharing a wealth of information that we're really excited to hear about. I don't want to give anything away, so I will let you share your screen, Randee, and if you want to tell about answering questions and all of that, yeah, I'll give you the floor.
Hey all, my name is Randee Waldman, as Lauren said. I am the director of the Juvenile Defender Clinic at Emory Law School. As part of that clinic, I represent young people in part in school discipline and special education matters. Prior to coming to Emory, which was about 20 years ago, I was a special education attorney for 6 years in New York City, and I've kept that up during my 20 years here at Emory. I was asked by Lauren today to speak about due process rights, the sort of what happens when it all goes wrong part of special education. And so that's my plan. I am happy to take as many questions as you all have. I teach for a living, which means usually I require people to answer me throughout my presentations, but apparently Lauren has muted you, so I can't turn the tables and make you all teach yourselves. But I'm happy to take questions. Lauren's going to monitor the chat. I'm happy to take them interactively as things happen. You're welcome to wait for a Q&A at the end, but also please jump in. My apologies in advance if my dog decides that he is tired of laying down behind me and wakes up and starts squeaking a ball or a toy really loudly, because that is likely to happen. So that's my heads up on the front end. All right, with that, that's sharing Zoom screen. Zoom does some weird things sometimes. That's my presentation. There we go. All right. Do y'all see presenter mode or regular mode?
It
Like
looks
you
like
see.
it looks like presenter. Can you flip one slide? Yeah, it looks like presenter.
All right. So it's one of those weird moments where from my home screen, it's backwards.
Can you do
Oh,
display setting?
yeah, I can swap. Now you're on regular.
Yeah, it looks good.
All right. It's like my home double screen is backwards. I don't know why. All right. So primarily we're going to talk about when things go wrong. I want to give 2 minutes of what is supposed to go right, what our goal is in the special education process. So every young person who is deemed to be a child with a disability is entitled to a certain set of rights and obligations by the school district. The first, most common, most notable is a free, appropriate public education. I will come back to that in a moment because that is not defined very well by statute. And so there is case law that defines what that means. They're required to receive that free, appropriate public education in what we refer to as the least restrictive environment, which means that they are educated with non-disabled peers to the greatest extent possible. That does not mean that every single student who is a student with a disability is always in a general education environment. It means there's supposed to be an individual analysis to determine the greatest extent possible that they can be provided services in a general education environment with non-disabled peers such that they are gaining from the educational system. Everybody has an IEP, individualized education program. And then for students with disabilities, there are specialized protections around discipline process, and there are some other procedural safeguards. The additional FAPE FAPE has gone through a lot of iterations in the case law, but the most important this case that's come out of special education in the last number of years is a case called Andrew F. And Andrew F tells us that school districts must offer children an IEP that is reasonably calculated to enable each child to make progress appropriate to that child's circumstances. Right? That means that FAPE it looks different for every single child. It is an individualized assessment to determine if the IEP that has been provided for the child is reasonably calculated to make that child make appropriate progress for their circumstances, which means child A and child B do not have the same IEP. They do not have the same level of progress from one step to the next step. And that we have to figure out how much should an individual child be progressing each year. The standard that replaced was called the Rowley standard. The Rowley standard, which meant was even less defined than that and didn't really individualize something. It was really to gain an educational benefit, but didn't tell you how much educational benefit was appropriate. And so we can come back to this when we're talking about individual circumstances, individual FAPE, but know that FAPE is defined directly tied to the circumstances of the child in question. Other rights, right? I identified that there are a whole bunch of other rights that come along with the IDEA. Those are defined the right to participate in IEP meetings. The IDEA is designed around parental participation, and it's designed around process. And when I say it's designed around process, what the IDEA looks like and what the case law has really said is that if we all get together at a meeting and we do this right, which means we create an IEP that is appropriate for the child through the processes that have been developed, the child will, at the end of the day, or should, end up with FAPE. And so it is a process-driven statute. And it's a process-driven statute that's designed around parents participating and being integral members. It is not school districts determining what is right for children. It is parents and school districts working together to determine what's right for children. And one of the greatest ways that they cannot provide FAPE to a child is to not include parents in the process. Excluding parents from the process is one of the quickest ways that you will find a not FAPE and a victory at the due process stage at the end of the day. Parents have a right to have an advocate present. That is defined in the IDEA as being either an attorney or a non-attorney lay advocate. It is one of the few places where lay advocates are able to participate, provide guidance, provide support, and to do so without the unauthorized practice of law. The IDEA specifically carves out an exception and allows lay advocates to participate. You'll find most of the lay advocates here in Georgia coming from our parent training and information centers, parent to parent being the primary. There's a right to access all of your child's records. If you ask for your child's special education file, they're required to give it to you. There's a right to an independent educational evaluation at public expense. If you disagree with the results of the evaluation that is done by the school district, there are two choices. You have option, you can ask for an independent education evaluation and the school district can either give it to you or file for a due process hearing. I find that more often than not, they just issue the IEE and give you an independent education evaluation because it is quite honestly cheaper than going through a due process complaint to fight about whether you'll get the independent education evaluation. That is, I will say the one area where they are less likely to give IEEs is when you're complaining about the lack of a dyslexia evaluation. So they really do put up a fight with some regularity on these IEEs with dyslexia. So we can come back to that. when we talk about the fights. Prior written notice of changes or refusals every time they change your child's program. And that could be the setting they're in, the types of services they're getting. Every time they change that or refuse to change that, if you have requested a change, they have to give you notice of that change or refusal with an explanation of why. Parents have the right to withhold consent for initial evaluations, and they also have the right to withhold consent for special education services to begin at all. So a parent has an absolute right to say, I do not want my child in special education. Dispute resolutions are written into the statute, and we'll come back to that. The right to compensatory education if they have not provided FAPE for any given period of time, and the right to attorney's fees if you're a prevailing party in a due process hearing. All of those rights belong to a parent, but they transfer to the child at the age of majority. Here in Georgia, that is at 18. That varies depending upon state. But in Georgia, that is at 18, and the rights transfer to the child. Again, there are some mechanisms by which a parent can maintain rights, and there's some shared rights that exist. They don't just vanish from a parent. But 18 is a magic age for us. All right, so that's my really quick overview of the IDEA because I think you've had some other webinars that have gone through that in much greater detail. What I'm here primarily to talk about is what happens when it goes wrong. You have gone through the IEP process. Your child is attending school and your child is not making meaningful progress. Your child is stagnating, is not getting the supports and services that you believe they need. What are your options and how do you approach them? The first option that is not totally written into the IDEA, but it is something that is relatively new. It is a collaborative, non-adversarial moment that is optional for states to participate in, but Georgia has decided to do so. And that is a facilitated IEP meeting. All you have to do is write to the state ed department and say, I'd like a facilitated IEP meeting. And if you do that, they will provide a neutral facilitator. That facilitator is not somebody who's just a higher up at the school district. That is a state ed neutral person who comes in to facilitate the meeting. I don't use them very often as a lawyer because I think of myself as my neutral facilitator, and I think of their school district's lawyers as their neutral facilitator, and we try and keep things on track. I have experienced one. What I'd say, and my goal in each of these is what are the pros and cons? Why are we using them? When do we use one of these versus another? I would say that the best use for a facilitated IEP meeting is when the communication has broken down. It's not so much that you're disagreeing about service levels and FAPE, but that you all just don't like each other. And you all just don't like each other, can't get along, you're talking over each other, you're talking across each other. And so no, progress isn't being made because you're not actually having a meaningful conversation. What the facilitator does is they come in and they set guidelines and they set up an agenda and they figure out what the outcome and desired outcomes for the meeting are. And they help lead a conversation that takes the personalities out of it and puts the issue back on what is it that we're actually talking about? What conversation should we be having? Can we keep it on a timeline? Can we keep it on task? Can we stop calling each other names? Right? That is a useful purpose, right? I've certainly participated in IEP meetings where I have come in. And when I have come in, you could see those tensions because the parent and the school district personnel are just not getting along. I promise squeaky toy. It has arrived. For those of you who have not, it's remarkably distracting for me. Not sure about the rest of it.
We can hear it.
He's not barking at me for not picking up squeaky toy. So I have found, right? So sometimes you come in and it's not like we're not even talking about what's best for the child because the parent and the school district, they're just at cross purposes and yelling at each other and mad at each other and calling each other names. The facilitator is the person who can take everybody to take a deep breath, focus on the issues, and move forward. They don't make decisions. They are not a member of the IEP team. They don't write IEP. They are facilitators, right? They are there to make us focus on the things that we should be focusing on. And they serve a real meaningful purpose in those circumstances where it's a personality conflict that just hasn't worked out. That's the crazy boy. Stop. Um, the next step, his nickname is Crazy Boy. Sorry. Um, that's the let's get along portion of this. The rest of these are really litigation tools, and they're litigation tools starting at the least litigious and moving on up to the most litigious. There are three options that are written into the IDEA in the litigation context. Option one is a state complaint. Option two is mediation, and option three is a due process complaint. And so my goal here is to go through each of those. This state complaint is the simplest of these, but also probably the one that gets you the least direct of an outcome. It can be filed by anyone. And by anyone, I mean it does not have to be the parent of a child with a disability. When I worked at Advocates for Children of New York, we filed state complaints with some regularity. We'd get some calls, we'd get some hotline calls, we'd identify that there's a problem in a school or a district, and we'd just send a message and say, hey, state, look into this. And they do. So some examples of things. One of the ones we filed in New York was that they weren't translating any of the special education documents into native language. And we wanted them to fix that, but we wanted them to fix that on a big issue. We didn't want them to like fix it for one child. We wanted them to fix it in the school district or in a school, like in one particular school. And so we filed a state complaint and said, hey, check it out. Another example that might work if you're in a school district and they just don't have, right, your child is supposed to be in a co-taught class and they don't have co-teachers in the classroom. That could be an individualized faith issue, but it also could be somebody in the community has learned that this is a thing and it doesn't have to be one of the children and just says, hey, can you look into this? They have all these kids with IEPs for co-taught classes, and there's no co-teacher in that room. State, look into this. They can give individualized relief. They can provide reimbursement for services that parents have outlaid. If it is a parent who's coming in with individual complaints about their child's education, they can also provide future provision of services for all children with disabilities. One of my colleagues at another law school in a different state filed a state complaint about special education services for an entire school district during COVID. And as a result of the state complaint, got compensatory services for the entire special education population in that school district. Right. And so those are the options in a state complaint. Some of its strengths, I find that a state complaint is most useful for systemic issues that I've talked about. It's quicker than due process sometimes. It's a 60-day timeline. The way it works is you file your complaint. The state then investigates. Part of that investigation is having a phone call with the person who made the complaint. Then they have a phone call or a conversation with the school district or the people involved on the other side. They do they gather documents from anybody who wants to provide them documents, and then they investigate and issue a decision all on their own. It's less costly, right? Because you're just filing it and sticking it out into the world. It doesn't cost anything to send a letter on off to the state and say, hey, you state, investigate this. and it doesn't have to be filed by an individual parent, right? And so again, these systemic issues, somebody else can jump in, somebody else can file, which might be helpful when you're looking at bigger issues. Weaknesses, um, you have a somewhat limited opportunity to make your case. And by that I mean you write your letter, and so you write as good a letter as you can, and then you usually have a phone conversation with somebody from state ed, and then it kind of is out of your hands. You don't get to answer the school district's response. You don't get to have a converse. You don't get to argue in front of a judge or an arbiter. You don't get to litigate the case. You just really put it out there in the world. There's no appeals. If you lose your state complaint, you lose. And it's possible that if you want to file a due process complaint, there's some conflicting information here. And so I say it's possible. It's also possible it won't, that it'll compromise a due process request for an individualized student, which is why sometimes I like to do that as a systemic issue, not on behalf of an individual student, as you start looking through those issues. Yes, Lauren.
Sorry to interrupt. We have a question in the comments. Somebody said, Tracy said, what do you mean by letter? I use the state's complaint form.
Yeah, state complaint form is totally fine too.
But can you also compose just a written letter and submit that as well?
Yeah, so when I do that, I usually just attach it to the state complaint form. State complaint form is short. I like to write more.
Okay.
So sometimes I'll fill out the state complaint form as a cover letter, and then I'll draft what is a much longer complaint. And but it doesn't have to be. That goes back to the question of the state complaint process. Once you put it out there, you're not litigating anymore. So I like to be as thorough as I possibly can and attach as much as I possibly can. And so personally, I find the form constraining, but it doesn't have to be. And it depends on what your issue is, and it's totally possible that your issue can be resolved in a paragraph by saying, like, school X, here's what they don't have, here's what they do have, here's what I'm looking for, and that's enough. But because this is my only chance in a state complaint, I try to be a little bit longer. Second issue is mediation. Mediation is our kind of compromise between the state complaint, where you just kind of put it out there, and our due process, where you're on full-on adversarial mode. Mediation, again, there is a form on the State Board of Ed form, and honestly, for mediation, I usually just use the state form. And the form, and the state will provide at district's cost a licensed mediator who will try to bring the parties together to come to a negotiated resolution. It must be voluntary on both parties. It can't be used to delay a parent's right to bring a due process complaint. So if a parent says, I want due process, and the school district says, let's mediate, the parent can say no. It can't be used to delay the due process portion. Must be done by a qualified and impartial mediator who's trained in effective mediation techniques. Some of them are better than others, I won't lie. Some of them are terrible, but they are indeed mediators. The state must select mediators on a random, rotational, or other impartial basis. They can't just choose a mediator and say, this is our favorite. They have to actually go through a wheel or a cycle. State bears the cost of the mediation. An agreement reached by the parties must be in a written mediation agreement, so it is a signed document that is binding. And everything that's discussed during the mediation process is confidential. You can't then throw it back at somebody and say, but you said, but you conceded, but you, right? It is an entirely confidential process that cannot be used against you in later litigation if you don't reach an agreement. The pros, again, it's relatively inexpensive. You can bring a lawyer to a mediation, but you can go in alone. It's quick, it's voluntary, and the agreement is enforceable. The weaknesses that I identified is it requires compromise, right? Everybody's going into, nobody's getting everything they want. And the biggest weakness for me of mediation is the power imbalance. The school district is a big old bully, and parents are on the other side of the big old bully. And a lot of times, what I see out of mediation agreements is parents go in without a plan. They go in without really knowing what they want. They go in saying, it's not enough, my child's not doing okay. And the school district comes back and signs an agreement that says, we promise to try harder and do better. But you haven't left with something concrete. So, what mediation for me, where mediation works, is if you have a parent who has a very clear understanding of exactly what they want and where they're drawing a line. I want 75 hours of one-on-one tutoring services, and the minimum that I'm willing to take in order to walk away and think I have an agreement is 45 hours. And you know going in what you want, and you know going in what you're willing to walk away with. If it's private school tuition, the tuition is $41,000. I know that I need 30 in order to be happy, right? And you have that hard line, and you have to be willing to walk away. If you go in saying, my child's not doing well, I want them to do better, the school district will get you to walk away and give up all of your rights by saying, but we promise we'll do better, without any concrete definition of what better means. And it will not be successful. And that, right, for me, is mediation's big flaw, is parents don't know what they want. And so that investigation has to happen before filing for the mediation. And if you don't know what you want yet, you're not ready to file the mediation request. Question there? I see the chat number going up.
Not really questions, just kind of some comments saying, oh, I didn't know that the district paid for the mediator. How common is it for advocates to sit in this process?
On mediations, it's common. So these vary a lot, right? So how adversarial and how strong districts are varies a lot by your district, by how litigation heavy your district is. And we have 180 school districts here in the state of Georgia. So what that looks like varies a lot across the state, and then over states for sure. What I have done mediation a couple of times. I have personally not found it helpful for me, but that goes back to, I think lawyers serve as mediators a lot. And by that I mean, I think lawyers talking to other lawyers is not very different and doesn't need the mediator most of the time unless those personalities get involved. And so I haven't found, personally, I have sent parents to mediation with my guidance and my, like, here's your plan, here's what you do, without me, without taking in the representation, without taking the case, without going all in, knowing that here's your bottom line, walk away and we can go to due process later. But it's not worth for me to take on representation at mediation, because I just don't think they add much value to me. But there are other attorneys who go to mediation a lot. The due process complaint has changed a lot over the years. In IDEA 2004 is when they created the early resolution process of the due process complaint that I'll talk about in a minute. And for me, that took over all of my mediations. It didn't used to be that when I filed a due process complaint prior to 2004, it just automatically meant we were going to a hearing. And now there's a mandated negotiation process, which to me is very similar to mediation, except that there's no mediator there. And I haven't found our mediators to be that skilled. Like I could trade numbers with another lawyer just as easily as I could trade numbers with a mediator between another lawyer. Like I haven't found them to actually be mediators so much as shuttle, like, relayers of information. But that just might be that might be me. So the last category is the due process complaint. It's the one we talk about most. It is the one that is utilized most. It can be brought by either a parent or the local education agency. Local education agencies usually will bring a due process complaint in a couple of circumstances. One, if they're fighting an IEE, an independent education evaluation. Two, if they're trying to get consent for initial evaluation of special education. They used to do those more because they also used to be able to force initial services of special education. And now that they can't force the services, they don't force the evaluations as often as they used to. And then that's really it for this district bringing due process complaints. Most due process complaints are brought by parents. Parent can represent themselves. I will tell you that in the state of Georgia, I very strongly discourage you from representing yourself at a due process hearing. You will not fare well. That was not true when I did this in New York. I sent parents unrepresented to hearings in New York all the time. I would never do it in Georgia. I would send them to mediation, but not to a due process hearing. Lay advocates can, again, don't have to be lawyers or an attorney. If you bring an attorney, the school district will also bring an attorney 100% of the time. Due process complaint can be initiated on any of the following issues: identification, evaluation, educational placement, or the provision of FAPE. Those overlap. I usually check all the boxes. Sometimes I'll leave one out because one of them is really not covered, but right. So we have the identification. They're a child with a disability. We agree with the classification, but I'll disagree with almost everything else. The statute of limitations is 2 years from when you knew or should have known of the violation. So at any point, you're really looking at a 2-year period of time from when you should be bringing that due process complaint. Occasionally you'll get some, but I didn't know and they hit it and I shouldn't have known and how was I to know? And so you can do a look back a little bit further than that, but not really you're going to be bound by this 2-year period of time. Complaint has basic information. The easiest way to get a complaint right is to use the form on the state ed website. I use the form on the state ed website, again, at least as a cover sheet 100% of the time so that I'm not missing information. If you're missing information, they can kick your complaint and that's not worth it. There's a form. You might as well fill out the words in it. The state has 15 days to challenge your complaint and 5 days for the hearing officers to rule on that challenge. And really what they're looking for is, have you described a problem and have you proposed a resolution? If the district can't figure out what you're complaining about, they will kick the complaint. But you will have another opportunity. It's not with prejudice. You can just file a new one. You can amend it. You can bring it again. The state is required, or the districts, or the LEA is required to file an answer to your complaint within 10 days. They have to, in their answer, explain why they either took or did not take an action as raised in the complaint. They have to identify other options that the team considered and the reasons why those options were rejected. They have to describe the evaluations, the assessments, the record that they use to make their determination, and a description of all other relevant factors. These answers are very closely aligned to the prior written notice that I talked about. I have not found a single district response to be illuminating for me. They're pretty pro forma. They don't really tell you a whole lot. they're lawyers talking in lawyer speak, denying or right there's not I don't find that to be a useful addition, right? I find the early resolution to be a useful addition. I don't find the answer to be a useful addition. And then the early resolution session, that's what I've mentioned before. Within 15 days of receiving the due process complaint, they are required to hold an early resolution session. Both parties can agree in writing to use mediation instead. Um, both parties can agree in writing to waive the early resolution session by saying it won't be useful, but it has to be both parties. So if you as a parent have filed your due process complaint and want to have this sit down with the district can't refuse you this sit down. If both parties come to an agreement and say, you know what, we've talked about this, we've hashed this, we're going to trial, you can get rid of that. I have not had a single case in Georgia that has not resolved in an early resolution session in my years since I've been here. Um, in New York, when I was asking for private school tuition, the school district told me straight up, we're not allowed to do that. I think they've changed their policies now, but they told us straight up, we're not allowed to provide private school tuition in early resolution sessions. So we just waived 100% of them. Right. And so, like, each district's going to be a little bit different on how they do that. But I've 100% of my due process complaints so far in the state of Georgia have resolved at an early resolution session. The meeting has to happen within 15 days. And then at the end of 30 days, if you haven't resolved your issues, the remaining timelines for the due process complaints start kicking in. And so there's this 2 week period of time where you've met, but you're still negotiating back and forth and you're resolving and you're putting things to paper. You get that period of time before your timelines start to kick in. Your hearing officer, right? You haven't resolved everything at the early resolution session. Your hearing officer is impartial. Here in the state of Georgia, they're all done by OSA, the Office of State Administrative Hearings. You can only raise issues at your hearing that were raised in the initial complaint. So if you didn't write it down on the front end, you're stuck not raising it going forward. You have the right to present evidence, confront witnesses, cross-examine witnesses, compel witnesses via subpoenas. You have the right to prohibit introduction of evidence that's not been disclosed at least 5 days before the hearing. So there are discovery rules. Each side has to share the evidence that they plan to use with each other. 5 days, quite frankly, is not that much time, but it is something you are at least required to review the documents ahead of time. There is a recording, and there are written findings of fact and decisions by the hearing officer. Case Schaefer v. Weiss that came out in 2005 tells us that the burden of proof is on the party that brings the hearing. So if you as parent bring your hearing, it is your burden of persuasion to convince the hearing officer that you should win. Before this, there were a lot of school districts that were, or a lot of courts that were holding school districts to a burden to prove they provided FAPE, no matter who brought the case. And so this allows some shifting in statutes, but in Georgia, the burden belongs to the parent if they are bringing the case. Hearing decision must be based on substantive grounds. If there's a procedural violation, the procedural violation. So if there's a procedural violation, let's say one of the team members wasn't there. They didn't have a gen ed teacher. They only had special ed teachers, and they were going through with the IEP. You have to prove that that procedural violation impeded the right to FAPE or significantly impeded the parent's opportunity to precision in the decision making or cause a deprivation of education benefit. It can't just be that they got procedure wrong. They have to actually still either interfere with a parent participation in the process. So if they had a meeting and they refused to do it at a time when the parent could come, that's a procedural violation that's substantive. But if they're just missing a deadline, but nothing really substantively it was impacted by that, you're not going to find a lack of FAPE because of the procedural violation. And then the decision is issued within 45 days. There is a concept called stay put, sometimes called pendency, which essentially says that while you're fighting, the child remains in their current educational placement unless everybody reaches an agreement otherwise. So it is a strategy if they're trying to move your child's being in gen ed with a number of services, and the school district says, you know what, I think this child needs to be in GNETs, or I think this child needs to go somewhere else. I think they need more restrictive. It is a strategy to file your due process complaint just to keep your child where they are and at the level of services they are currently getting while you are fighting about that. On the flip side, if you want more services, you're not getting those more services while you're fighting this out, unless there is an agreement otherwise. Which brings us to the important part, which is that's not remedies. What can you get through these things that I have just told you about? And the answer is, if you can dream it, you might be able to get it as long as what you're asking for is not damages. What the IDEA says is that the remedy is equitable. We are supposed to put the child back in the place that they were if the deprivation of FAPE had not happened. Things that are on there, right, that I put on this slide is the most common things, tutoring, right? And so we don't call it tutoring, we call it compensatory educational services in the form of reimbursement for privately obtained tutoring services, private school tuition, and the IDEA actually has statutorily codified the private school tuition that came out of case law. Additional or extra speech or language services, occupational therapy, physical therapy, counseling, psychological services, right? All of the related services that come out. It could be transportation. My favorite case for failure to provide transition services. New York was doing a really bad job of transition services for a long time. And honestly, a lot of school districts provide a really bad job of transition services. I asked the school district to send my child to refrigeration and air conditioning school. We had a series of, we just had a whole project around transition stuff. And so we had the school district send our kids to Fashion Institute of Technology. Right, Voc schools. We just kept making the school district pay for Voc schools and winning those. And so the question is, what have they failed to provide? And as they fail to provide it, what can you ask for to put the child back in services, right? Not give me $5,000 in damages, but give me $5,000 worth of services that you missed out on. And then if you go to a due process hearing and you win, you are entitled to attorney's fees. So if you've paid your lawyer, you can get those services reimbursed. Private school, this Burlington is the case that says you get private school. I identified that it's statutorily codified. So I'll focus on the codification. It can be ordered if the agency has not made FAPE available and the private placement is appropriate. Private placement is appropriate doesn't mean it has to be state authorized, doesn't mean it has to provide FAPE in the same way, doesn't mean it has to be a special education school. You have to, appropriate is defined as something less than FAPE as a general rule. If you are going to place your child in a school and seek reimbursement, you do have to give 10 days notice to the school district that you plan to do so before you do it. You don't have to seek that reimbursement for 2 years because you have a 2-year statute of limitations, but you have to give them 10 days notice before you do it, or you will lose on equitable grounds, or they will decrease your funding on equitable grounds. I think that's so some strengths and weaknesses of the due process complaint. Strength, it is about your kid. It is 100% about the child who is in front of them. It allows you to bring in attorneys and advocates. There are due process rights. There's evidence. There's cross-examination. It is like a litigator's dream, right? You can put your case in front of them. It's legally binding. If you lose, you can appeal. The weaknesses are it is very time consuming, especially if you're going through an appeals process. It can be very costly. Special education lawyers are not cheap. They have very high retainer agreements. They have very high hourly rates. They are very costly in the special education process. It is winner take all. You either win or you lose. You're not splitting the game, right? At mediation, if you go in asking for the cost of tuition, you can agree to take $10,000 less than the cost of tuition. If you go to hearing and you're asking for tuition, the hearing officer is going to say you either win or you lose. You were either denied FAPE or you weren't denied FAPE. They're not going to split it down the middle and say, let me give you half tuition. It's just not, it's a winner take all system, and it is very adversarial, right? You have gotten to the point where we are fighting, right? Where there's no turning back once you get there. All right, that is where I will stop and take other questions.
Fabulous. We do have two questions in the chat. One of them is mine, so we'll do that one. Well, we can wait on that one. But Mabel asked, are there any legal resources? Oop, it's cut off. Uh, we can use as parents to ask general questions about IEP. Um, I think maybe, Mabel, do you mean like within IEP meetings, or I don't know if you need clarification from that, Randee?
Um, yeah, I think. Are you? Is this where like they're not allowed to come off mute?
No, no, Mabel, if you want to come off mute and kind of clarify what you mean, or if you want to just keep responding in the chat, but I guess
I
you
have
want.
I have a
Yeah.
question. It's regarding to like say they do an IEP evaluation, say for speech therapy, like for my son. He had speech therapy, and I kept on bringing up the issue of dysgraphia, and he was in second grade, and they were informing me that at that time they could still write letters backwards. But I started to notice that there was something more going on, and as time went by, I started to notice that he may have dysgraphia. And at that moment, like as a parent, when you're trying to vouch or advocate for your son for more help, like occupational therapy, right? Or as well as technology, right? Assistance. I just felt like, what can I do as a parent if for some reason, when you brought this up, it wasn't addressed, if that makes sense.
Yeah, that's so there are a couple of options. One is truly, right, try a facilitated IEP meeting, right? That's going to be the cheapest, the easiest, the quickest. See if you can. But if it doesn't sound like in that circumstance, it sounds like the district just disagrees with you, right? It sounds like in that circumstance, they're saying, you know what, we should wait and see another year, another 2 years, to which your answer is, how much longer should I wait while my child is falling further and further behind?
Exactly. Mhm.
Which gives you the option of, that's when I'd ask for an IEE, because their choice is to either give you the IEE or file a due process complaint. They have to act. They can't just say no. So if you ask for an IEE, their choices are twofold: give you the independent evaluation or file a due process complaint. And so that forces their hand. I would probably that's a decent issue for mediation, where you're not going to file an attorney if you've done the evaluation yourself, right? So sometimes you can get insurance to pay for the evaluation. If you've gotten insurance to pay for the evaluation, you can submit the evaluation. They're legally mandated to consider but not abide by the evaluation that's been provided privately by a parent. And at the end of the day, if you think your child needs more services and the school district just doesn't, That's where these due process complaints, that's where this comes in, right? You either mediate it or you go for a due process complaint. And I find that dyscalculia, dysgraphia, dyslexia, all the dys words, right? That is where they start fighting, because they say it doesn't matter if it's dyslexia or if it's a learning disability, we only classify learning disabilities. And like, great, but they need the services. I don't care what you call it. And they push back. And so that's really where you're going to start having to use these dispute resolution processes. And I would probably start either with a lawyer consult. Just getting the evaluation is probably too costly to go to the lawyer consult. I'd probably start with asking it, writing the words independent education evaluation. And if they deny it, they'll do the due process. I'd probably jump into mediation at that point and see if you can't get an evaluation out of them. But at the end of the day, if they're not doing it, you're going to have to go to a due process complaint to get it happening.
Thank you. I appreciate that.
Is there a cost to file due process, Lauren? That's your, the answer is no. Parent can absolutely file for a due process complaint on their own. It is, like I said, in New York, I would send people to due process hearings by themselves 100% of the time. New York City was set up very differently. All of their due process hearing officers, all of their impartial hearing officers were run out of the New York City Special Education Office. They were all hired with their sole purpose of being to hear special education complaints. They were all experts in special education matters. And quite frankly, they all understood FAPE to a degree that they didn't require a lawyer to show them the missing FAPE. Given that, parents went there and won all the time, but there were 1,400 special ed hearings my last year there. And there are about 9 or 10 special ed hearings a year in Georgia. They're done by OSA hearing officers who have no expertise or training or specialization in special education matters. And the school districts here are way more litigious. And my hearings could be 4 hours in New York and they're 4 days in Georgia, right? I would never send, they are free, but I would never send a parent there alone, like ever.
Mm-hmm. Yeah. Yeah, thank you. There's another question in the chat, and it's you can read it, but it's
Yeah.
about like not making adequate progress with an IEP and wanting structured literacy.
Uh, so
Sorry,
the
it may be too much information for
yeah,
here, but just to clarify, she did have an IE. I got the district did pay for it, but now they're not recognizing the findings, and she's not making adequate progress.
yeah. So
They're only
the thing
recognizing
is
my checks.
they're probably recognizing the findings. They just don't like your solution. What school districts will generally identify is that they do not take recommendations for how to teach, right? They will never teach like if you say I want structured literacy, they'll say we get to teach how we want to teach when we want to teach. This is our field, right? And so for me, when the child is 2 years below grade level, depending upon IQ, depending upon ability to progress, right, depending upon a lot of things, that for me, right, not receiving FAPE. And if they won't teach the way you want them to teach inside the school system, right, structured literacy program, that's when you do a due process complaint for private services, right? You say you have failed to provide FAPE. My child did not make my child did not make progress commensurate with her abilities, right? The Andrew F standard. And in order to win at a due process hearing on that, you're going to have a psychologist who's going to come in and say, with the right supports and right program, they should have advanced a full grade level over a period of a year, because that's what general education students do. And they didn't, and therefore they didn't provide FAPE. So the legal argument is they didn't get FAPE because they didn't make adequate progress commensurate with their abilities. The solution isn't to force them to do structured literacy because you're never going to force them to use a specific methodology. All of the fights early on autism where you can't force them to do ABA. All of the fights on dyslexia, you can't force them to do Orton Gillingham. All of the fights around school district stuff is you can't force them to use a specific methodology. That's their decision. But you can say you didn't provide me services and now I'd like reimbursement for tutoring in the form of private tutoring at X dollars an hour for however many hours. And that is how I met Lauren, which is I have done due process hearings where I've gotten tutoring like that privately because the school district refuses to provide literacy training. Like they just don't teach kids how to read or quite frankly, how to do math. And so, right, what I do is I go in and I say, fine, you've been given your shot. The answer now is give me my money so that I could get that shot elsewhere. And
So it would be
that's
a due
what
process. I would
due
request a
process
due process hearing.
or mediation. You
Okay.
can absolutely get that out of mediation. And that's a prime example for a mediation and a walk away, right? What I want is 100 hours of private tutoring, and I'm making up a number, right? It could be you want 20, where I'm making up a number for what you think it would do to make up for the year of services where she didn't get what she needed.
Mm-hmm.
And they come back and they say, we'll give you 6. And you're like, no, we're going to walk away. And then you can think about a due process hearing. But if you
Okay.
walk in and you say, I'm asking 100, but I'll walk away. Like if they offer me 60, that's my walk away point. I'll leave happy. Then that's what you do. And that's an easy one to know what your walk away point is because you have a clear goal, you have a clear request, you have a clear, nope, I'm walking away point. And if you don't reach an agreement, you don't reach an agreement, but you have to be willing to walk away.
And so I would do, because I was going to ask for another meeting because she only has one reading goal. And I know that's inappropriate because I've talked to a few advocates. So I was going to go at one more meeting and say, I want all of these goals in place, which they cannot meet unless they do something else. But should I just go straight to mediation or just do that in addition? And then after,
We're frankly at the end of his school year, so time's not as much of the essence. I would, I think that depends on the relationship you have with an individual school district.
yeah,
There's no harm in going back and saying she can't, right? She needs a reading goal.
yeah,
She needs a literacy goal. She needs, right? All of these things that come out of the IEE that tell you what kind of goal she really needs.
yeah.
I I fight for goals with some regularity, but I don't find that they are meaningfully helpful to the advancement of knowledge by my clients.
Yeah.
So I think they're good to data monitor, right? It is helpful for me to see that my child's not making progress on their goals and that they have the same goals every year.
Mm-hmm.
I don't find that my client meaningfully benefits from having the goal other than to demonstrate failures of a school district personally.
And would I need to take a lawyer to mediation or wait until due process?
I think you can do mediation alone, right?
Okay.
If you go in knowing that you're not going to be a pushover, right? That's that power dynamic. So if you go in with
Mm-hmm.
your ask and with your walk away point and with the strength and fortitude to actually walk away, you can 100% do that alone.
Okay. Thank you.
But you need all of those things. If you're going to walk away with, I got 6 hours and I allowed it to be by a district professional who has no training, you just lost mediation.
Mm-hmm.
So you have to really know what you want and what you're willing to accept and what you're willing to walk away if you don't get.
Got it. Thank you.
Tracy's question, the answer is ish. So there are for sure not enough pro bono legal services in the state of Georgia. I come from New York where we had free legal services all over the place. And I am in Georgia where we don't. I'll say that the Juvenile Defender Clinic is first and foremost because I work through law students with our goal and desire being around school discipline and being around juvenile delinquency. So most of the special education work, all of the work I do is free. So I don't actually ever charge parents. That's the good news. All of the work I do is pro bono, but it is primarily delinquency clients who find themselves in need of special education or school discipline representation. That's collateral to their delinquency stuff. I do occasionally take cases because somebody has given me a sob story that I can't turn around from, right? So I've done a special ed case for a young man who was 20 and called me on his own um, and said, I've been in this IEP diploma track all these years and I had no idea. And they're just now telling me I'm not getting my diploma and walking at graduation. And here's all the ways they messed up. And if you call me at 20 and call me on your own and your mom don't call me, I'm going to take your case every time. Like the secret to getting me is to have the kid call, not their mom. Because I will take that case 100% of the time. And I worked with that kid for years, and he did indeed graduate and walk across the stage with a full on general education diploma and is now, I believe, a nurse.
Oh.
So it's every now and then I'll do the if I think I can make a meaningful difference quickly. More on the discipline side because when I take a special ed kid and I start with them when they're in second grade, then I have 11 more years of representation. So I can make a meaningful difference, but boy, I'm stuck with them for life. Whereas if I do a discipline case and I can get in, get out, and I think I can make a meaningful difference, whereas a parent was not going to be able to fight it on their own, but I think I can. I sometimes take those. So like I do make exceptions, but it is not my norm.
Well, this has been really enlightening, and I have learned a lot. And I thank all of you guys for coming and spending your Monday evening with us. Um, we this is recorded, so we'll share it with everybody who is present. We'll also put it on our YouTube channel. Um, if there are any specific questions about anything that you spoke about, Randee, is there a way that anybody can reach you? Do you share your email address, or should they reach out to us and maybe we can relay? What do you prefer?
I mean, my email address, if you Google Randee Waldman, I'm the only one in the country, in the world. I'm easy to find. My email address is on Emory's website, so
Fabulous.
I get questions all the time. I'm happy to
Fabulous.
continue to take them.
Great. Well, this has been great. Thank you so much. And we hope that all of you will, continue to um, join our webinars. They're bi-monthly. We have fabulous presenters such as Randee who share knowledge with the community. Dina, is there anything else that you'd like to share before we head out? Randee, is there anything else you want to say to wrap up or?
I think that's all. I'm going to take my background off so that you can all see he's falling asleep again.
Oh, yes. I was hoping we
Yeah,
would see Crazy Boy. Is
that's
that what
all.
it is?
Crazy boy. Crazy boy.
Hi, there you go.
Again.
It's a good way to wrap it up.
There you
Well,
go.
thank you so
Everybody, see,
much, everyone.
he's like,
Oh,
are we good? Now we're up.
now we're up. Now it's party time. All right, everyone. We'll have a fabulous evening. Thank you so much again for your time. And thank you so much, Randee. We appreciate you very much. And hopefully see you all soon.
All right, thanks all.
Thank you.
All right, I was trying to see the last questions.
I think we got everything. Will it be
All right. Yeah.
recorded? Yeah.
All right. See y'all. Have a good night.
All right, Randee. I'm going to go ahead and end the meeting. I'll talk
Yeah.
soon. Thanks so much.